Can you begin, Sarah, by telling us what our obligations on labour law are under the backstop provisions?
So what the backstop says is that during the lifetime of the backstop, the UK won't reduce the level of employment standards that exist.
Won't reduce, is that the phrase you used? Yeah.
So in terms of what we have at the moment, it's essentially a non-regression clause. So whatever employment protection is in place at the end of the transition agreement, that is what will then go in place throughout the backstop. What it doesn't do is it doesn't commit to keep pace with developments that take place in the EU after we have left the arrangement. And what it doesn't do is set out an international enforcement mechanism. So at the moment, if you want to enforce your employment rights, you can go to courts in the UK, you can go to the Court of Justice of the European Union. Infringement actions can be brought by the Commission against member states. All of these things have happened to the UK, and we won't have the benefit of any of that stuff, and instead you'll be relying on the domestic legal system to enforce your rights. So actually, even though there's not going to be a regression of your rights, your enforcement of them will be a bit tougher. It won't come necessarily with the interpretation of the Court of Justice of the European Union. So actually, there is a bit of a loss all round, I would say.
Okay, let me tease out some of that if I can. First of all, on this business about non-regression or dynamic, let's take an example. If, for example, the EU were to agree a new posted workers directive, which developed rights in that area, quite an active area of discussion, under the backstop provisions, there is no compulsion on the UK to amend its law in line with whatever that new directive would be. Is that?
Yes, that's completely right. And in the specific example of posted workers, we know that when it was being discussed at the level of the Council, the UK abstained. When it was discussed at the European Parliament, Conservative MPs abstained on those votes. So you can kind of read into that under the current government, we'd be likely not to adopt those kind of progressive measures, yes.
Okay. In these cross-party talks that are taking place, this issue of dynamic alignment of rights is quite live. I'm a Labour MP, and my party is asking for dynamic alignment. So to take that posted workers directive example, as I understand it, what we are asking for is a commitment from the government to align with such future directives. But there's a question then of enforcement, which you raised. And enforcement at the moment is fairly regularly through the ECJ. It's not a rare thing for employment cases and employment law cases to be held before the ECJ. So could you tell us a little bit more about, even if there was a political agreement on dynamic alignment in the future, what would be the recourse to enforcement mechanisms for a worker seeking to enforce those rights?
I mean, this is where we come to a bit of the problem, and one of the TUC's concerns throughout this whole process is, basically what we want to do is look at the kind of protections that working people have right now and make sure that whatever happens, whichever deal is adopted, there's absolutely no reduction in those protections. And it's not just the laws that are written down that are the protections, it's how they're enforced. And a very particular feature of the Court of Justice of the European Union is that in the area of labour rights and labour standards, it's historically adopted a very broad interpretation. It's tried to make sure that as many people can benefit from a right as possible. It's managed to keep laws up to date and kind of help the law make sense a little bit. Equality, discrimination law can be quite complicated, and the court has really helped us to work through those issues. And we want to hold on to all of that under whatever future deal we have. Now, we would really, really welcome the government saying that it would commit to dynamic alignment, but for as long as we sit outside the CJEU or some other independent judicial system, there will certainly be a loss of enforcement rights for workers here in the UK. If I'm completely honest, really anything short of an international agreement that we will have dynamic alignment and that there will be some sort of additional arbitration process that individuals can access themselves, because that's another thing that they can do to the Court of Justice, then that would be a loss for working people here in the UK, and we would find it hard to back up MPs who wanted to vote for that sort of deal.
I think you've raised a very important point there, because what you're saying to us, correct me if I get this wrong, I don't want to put words in your mouth, what you seem to be saying is that dynamic alignment, for that phrase to be meaningful, it's not just a question of the legislation, it is also a question of the enforcement mechanisms, because very often how rights are translated into real practice on the ground doesn't just stem from the legislation, it stems from ECJ judgments. So absent that pillar of those kind of judgments, we're not in the same situation, even if we have on paper an agreement to dynamic alignment.
Yeah, that's what I'm saying.